Dear friends and colleagues, chers amis, queridos amigos. Es increíble pensar que todo un año ha pasado desde que empecé mi presidencia en Macao. A veces he tenido la impresión de que he pasado casi todo el año en los aviones. Sin embargo, estos vuelos me han llevado a lugares extraordinarios y me han permitido relacionarme con gente inolvidable y conocer ideas remarcables. Merci aux Espagnols. And most important, these flights gave me the opportunity to spread the word about the UIA and what we stand for in many far-flung corners of the world. Whether in Hong Kong, Japan, or New Zealand, in Australia or Russia, or in Saudi Arabia, Kuwait, Canada, or the United States, to name only some of them, I have told the unique story of the UIA to lawyers and government leaders alike, that we are the world's first international association of lawyers, bars, and law societies, that we are the only such association that is committed to multilingual and multicultural diversity in everything we do, and most important, that we stand for democracy, human rights, and the rule of law. C'est un moment tout à fait exceptionnel que nous allons passer ensemble à ce remarquable congrès de Florence, dans cette ville lumineuse de beauté, d'art et d'histoire. Nous en sortirons rafraîchis, renforcés, redédiés à nouveau à poursuivre notre métier qui a pour but la protection des citoyens dont nous sommes les premiers et trop souvent les seuls défenseurs. Selon la tradition de l'UIA, c'est à la cérémonie de clôture où le président dresse le bilan de son mandat, et je le ferai effectivement samedi. Mais à la cérémonie d'ouverture, en revanche, il appartient au président d'attirer l'attention de l'association à un défi, un danger, une menace juridique qui pèse sur notre profession et auquel nous devons faire face avec fermeté. Malheureusement, il n'en manque pas, et je serai donc fidèle à cette tradition aussi. Comme vous le savez, l'une des plus importantes activités de l'UIA est ce que nous appelons la défense de la défense, où nous intervenons, quel que soit le pays concerné, là où nous estimons que nos confrères sont menacés, punis, persécutés ou poursuivis simplement du fait d'avoir exercé le métier d'avocat. Le plus souvent, c'est dans les pays en voie de développement que nous sommes appelés à intervenir, là où la démocratie n'est pas encore fortement enracinée. Toutefois, vous serez certainement d'accord avec moi que nous serions injustes et hypocrites si nous prétendions que seuls les pays les moins développés soient atteints des menaces à la liberté et à la sécurité juridique du citoyen. Au contraire, c'est parfois dans les pays les plus sophistiqués et prospères que la menace pèse le plus fortement. Parfois, et c'est le cas ce soir, nous devons donc nous soulever au soutien de nos confrères d'un pays muni d'une longue tradition démocratique et juridique, mais confronté aujourd'hui d'un grave risque aux valeurs fondamentales de notre profession. C'est donc d'un pays qui m'est très cher que je vous parle ce soir, le berceau des droits de l'homme et du citoyen, la République française. Et je salue la présence parmi nous de M. le bâtonnier du barreau de Paris, qui a mené une lutte exemplaire contre les abus de pouvoir dont je vous parlerai maintenant. Nous lui disons que sa lutte est notre lutte. It happens so often in France that it has become almost routine, in Paris and elsewhere, sometimes as often as 3 or 4 times a month. Generally late in the afternoon, the bâtonnier, the president of the bar, receives a phone call informing him or her that the following morning, the judicial police will conduct a forcible search of a lawyer's home or office. The bâtonnier or his representative can be present, but can do nothing to limit the search other than to object to it on the lawyer's behalf. The preferred technique seems to be to conduct the search of the lawyer's home in the very early hours of the morning, to take everyone by surprise when the lawyer and his family and his children are all there, often still in their night clothes. It must seem to the lawyer that the timing is designed to maximize the invasion of privacy, the embarrassment, and the intimidation that result. Documents, computers, files of all sorts are seized and carted away. The sanctity and the security of the lawyer's home or office is violated, a violation that once committed can never be repaired. As an American lawyer and a former prosecutor myself, I would have assumed that such a search could only take place if it were based on significant prior evidence that the lawyer himself or herself was engaged in criminal activity. Indeed, I would have expected that such a search, any such search, whether of a lawyer or of any other person, would require such prior evidence. Though it certainly would be deplorable if as many as 3 or 4 French lawyers each month were actually committing crimes. If that were the case, no one could argue that such searches, properly supported by evidence and properly authorized by an independent judge, should not be conducted. But in fact, in the overwhelming majority of cases, the lawyer whose home or office is the target of such a pre-dawn search is not suspected of any crime. The only crime he or she has committed is the crime of being a lawyer, the crime of representing a client whom the authorities suspect of wrongdoing. Instead of conducting a search of the client's home or the client's office, the prosecutors and police descend upon the lawyer's home or the lawyer's office in the belief, often justified, that the lawyer has received documents or other evidence from his or her client for the purpose of giving advice as to the client's rights or preparing the client's defense, documents that will be useful to the investigation being conducted by the investigating magistrate. In French, there is an expression that lawyers are auxiliaires de justice, auxiliaries, officers of the judicial system. In English, we say that lawyers are officers of the court. But being an auxiliaire de justice, or an officer of the court, does not mean that we can countenance a system in which lawyers tell their clients that confidential communications between client and lawyer are protected by professional secrecy, where clients turn over to their lawyers their most private and sensitive documents so that the lawyer can study them and provide legal advice about the client's legal rights and obligations. And yet, a system where the police and the prosecutors can then take advantage of the lawyer's work and the client's trust by swooping in to seize the client's documents from the lawyer on the sole authority of an investigating magistrate, the juge d'instruction, who sometimes is far more of a prosecutor than a judge. So in effect, the lawyer becomes the prosecutor's unwilling tool, the unwilling but helpless source for incriminating evidence against his own client. This is a cynical perversion of the attorney-client relationship, and indeed it destroys that relationship, because in penalizing the client for having trusted the lawyer and for having believed the lawyer's assurances of professional secrecy, it makes it impossible for the client ever again to confide in the lawyer. Yet that is what happens in France today again and again and again. It is an outrage that has become almost routine, and it is time for it to stop. As I said in my inaugural address in Macau, I think it is important for lawyers and judges to work with each other as colleagues. I have tried to bring more judges from many different countries into the work of the UIA. And the UIA is a determined fighter for judicial independence because it does no good for lawyers to be free to practice our profession if the judges before whom we appear are not free to practice theirs without political interference. That is why the UIA strongly supports, for example, the lawyers and judges of Hong Kong in their struggle to maintain judicial independence and the rule of law in the face of efforts of the Chinese government to restrict it. And I have no doubt that French judges, like judges everywhere, are doing the best that they can to exercise their substantial power and their authority in good faith and in accordance with the law. But sometimes the law needs to be changed to protect the rights of the people. Judicial independence cannot be allowed to mean judicial irresponsibility. In France, there is no requirement that before taking what should be the extraordinary step of a forcible search of a lawyer's home or office, the police, the investigating magistrate, or the prosecutor must present to a neutral and independent judge, unconnected with the investigation, evidence of the lawyer's personal participation in criminal conduct. On the contrary, the same investigating magistrate who is directing the police investigation has complete and unfettered authority all alone to order the pre-dawn search of a lawyer's home without making any showing to anyone that there is any reason to believe that that lawyer is engaged in wrongdoing. Then the investigating magistrate and the police are free to rummage through whatever they find, whether it relates to their investigation or not, and regardless of whether it discloses the confidential information of other clients who have absolutely nothing to do with the matter under investigation. Nor can it be said that this kind of abuse of the lawyer-client relationship is justified by the need to enforce the criminal law. In the United States, for example, every person, lawyer or not, has the constitutional right not to be subjected to a search of his home or place of business unless the authorities have first presented to what our Supreme Court has called a neutral and detached magistrate, a sitting judge who is completely unconnected with the investigation, proof that is sworn under oath that this independent judge finds sufficient to establish probable cause to believe that the person whose home or office is being searched has committed or is in the process of committing a crime, and that evidence of that crime may be found at the premises to be searched. And if the target of that investigation is subsequently charged with a crime based on the seized evidence, the judge presiding over the resulting trial will look at the evidence presented to the authorizing judge yet again to ensure that there was indeed sufficient evidence presented to the authorizing judge before the search to justify the invasion of the target's privacy without taking into account anything that was found during the search. And if there was not sufficient evidence before the search, all of the evidence seized in the search will be excluded from the trial. Please understand, I am not suggesting that the American system is without fault or that other countries should adopt it. On the contrary, our system is far from perfect. And in any event, each country must have the right to adopt its own criminal procedure according to its own culture and its own values. I am simply using the United States as an example because it is the system I know best, an example of the fact that a country can effectively investigate and prosecute crime without giving unfettered, unchecked authority to an individual prosecutor or investigating magistrate, and without permitting that prosecutor or magistrate alone and without having to answer to anyone to turn an attorney who has committed no crime into an unwilling witness against his or her own client. Such a system does, in fact, turn judicial independence into judicial irresponsibility. No one man or woman acting alone should have such unlimited power. Je vous ai dit quand j'ai pris mes fonctions à Macao que l'avocat est avant tout le bouclier du citoyen. Seul l'avocat, ai-je dit, s'érige entre son client et l'autorité parfois arbitraire et impitoyable exercée contre lui, notamment par l'État. Je vous ai dit aussi que tous nos concitoyens ne partagent pas forcément l'opinion que nous nous faisons de nous-mêmes. Pour eux, trop souvent, les réclamations des avocats et des barreaux pour la protection des avocats ne relèvent pas de l'intérêt général, mais plutôt des tentatives corporatistes destinées à nous construire une sorte d'immunité personnelle au-dessus des lois. Vous savez tous qu'il n'en est rien. En ce qui concerne les perquisitions des cabinets et domiciles d'avocats, ainsi que les écoutes des conversations confidentielles entre avocats et clients, nous exigeons tout simplement que 3 principes fondamentaux soient respectés. Tout d'abord, que seuls les avocats dont la justice possède au préalable de toute écoute ou perquisition des preuves sérieuses et concordantes de la criminalité de l'avocat lui-même ne soient assujettis aux perquisitions et aux écoutes. Deuxièmement, que la suffisance de ces preuves préalables de la criminalité de l'avocat soit validée avant toute perquisition ou écoute, non seulement par le procureur ou le juge d'instruction qui dirige l'enquête, mais aussi par un juge du siège neutre et détaché, sans aucun lien avec l'enquête, qui sera en mesure de ne donner son accord à une mesure tellement destructrice de la relation avocat-client que dans la mesure où l'avocat lui-même s'est livré à des actes criminels qui le privent du droit de réclamer la qualité d'avocat. Et troisièmement, lorsqu'une personne est mise sous écoute et par conséquent un entretien téléphonique entre cette personne et son avocat est intercepté de manière incidente, la police doit cesser d'écouter dès lors qu'il paraît qu'il s'agit d'une conversation client-avocat. Et en tout état de cause, le contenu de cet entretien ne peut être ni transcrit, ni versé au dossier, ni utilisé de quelque manière que ce soit. Les enjeux en sont graves, pas simplement pour nous, mais encore plus graves pour nos sociétés et nos concitoyens. Nous devons convaincre nos concitoyens que ce n'est pas nous-mêmes que nous souhaitons protéger quand nous nous élevons contre les perquisitions mal fondées et les écoutes abusives. Nous, les avocats, on sait se défendre, c'est notre métier. Mais que feraient-ils nos clients, nos concitoyens, si nous ne pouvions plus les protéger, si nous ne pouvions plus les conseiller, si nous ne pouvions plus leur expliquer leurs droits et leurs obligations, afin qu'ils puissent se mettre en conformité avec la loi, sans que les secrets les plus intimes qui nous confient en toute bonne foi ne soient détournés contre eux. Et que deviendraient-elles, nos sociétés? Que deviendra la France, berceau des droits de l'homme, si l'État pouvait, avec une totale impunité, continuer à instrumentaliser les avocats en les rendant rien de plus que les agents de la police judiciaire, des rassembleurs de preuves à charge, sous couvert d'un secret professionnel qui n'est plus digne du nom, afin que la police puisse débarquer chez eux à 6 heures du matin, saisir pour poursuivre ce que leurs clients leur ont confié pour défendre. Lawyers simply cannot allow this to happen, not in France, not in the United States, not anywhere. Whether the violation of the lawyer-client relationship is a search of the lawyer's home or office, or the interception of the lawyer's confidential conversations with a client, whether the purported justification for the violation is a criminal investigation or national security, whether the source of the violation is France, the United States, Italy, or any other country, all lawyers and all lawyers' associations must be vigilant in protecting not ourselves, but rather our clients and fellow citizens. Our focus must not be on the rights of lawyers, but rather on the rights of the people. Let's face it, our elected officials respond best not to high-minded legal arguments, but to political reality. To that end, we must make it politically untenable for our elected officials to permit improper surveillance. We must make it politically untenable for our elected officials to permit prosecutors to flout the protections of attorney-client secrecy. We must make our fellow citizens think about what kind of country they want to live in. A country where a person can seek the counsel and assistance of a lawyer with confidence that what he tells the lawyer will not be disclosed to the state, or a country in which Big Brother is everywhere and no confidence is safe. We must make that case. We must fight against the kind of public cynicism that thinks that every secret hides wrongdoing and that every confidence, therefore, must be revealed. We must make our fellow citizens understand that lawyers are there to help and protect them, and that when governments choose to infringe on lawyers, they are really infringing the rights of everyone. Only then will the people insist, with the power of their votes, that their representatives protect and preserve the sanctity of the attorney-client relationship. All around the world, whether in Hong Kong in the last few months or in Malaysia in the last few weeks, whether in Russia or in Saudi Arabia or indeed in France or the United States, lawyers must continue to be the early warning signal, the ones who sound the first alarm whenever the rule of law is threatened, constricted, or suffocated. That is why tyrants seek to silence the lawyers first, because they know that if they do not, we will speak out. Our vigilance against the erosion of the rule of law and the persecution of the lawyers who defend it must be constant and tireless. And it has been an honor for me to carry that flame on your behalf in the past year. My time as your president is coming to an end, but our determination as lawyers to fight for the rights of our fellow citizens can never end. Though I turn over the reins of this association to my friend Miguel Loynaz on Saturday, I pledge to you that my own commitment to the cause of justice and the rule of law will continue. I urge all of you to join me in that struggle, for there is no more noble task in this world than to speak out for the protection of our fellow citizens, to place ourselves in the way when the strong seek to victimize the weak, and to ensure that the world we pass on to our children will be one where power is tempered by law and where law is tempered by justice. Thank you.